Let's start with spousal maintenance, which people often call alimony.
Exactly. Spousal maintenance or alimony is one spouse's legal duty to provide financial support, usually income, to the other spouse after divorce. It's typically awarded if the court finds the recipient spouse can't provide for their own reasonable needs.
And how long does it last?
It varies. The source says it can be for a definite period, maybe temporary to help someone get back on their feet, or sometimes indefinite, often after a long marriage. A really key point the source makes. The obligation to pay spousal support cannot be discharged in bankruptcy.
Ah, another bankruptcy protection. You can't wipe out alimony debt that way. How do courts decide the amount and duration? Is there another list of factors?
Yes, similar to property division, courts weigh several factors, figure 3A in the source. They look at the financial resources of the spouse seeking support, including the property they got in the divorce. They assess each spouse's earning potential and, importantly, the obliger's ability to pay. The standard of living during the marriage is a benchmark. The time needed for the recipient to get education or training to find appropriate employment, this links to the goal of rehabilitation. The length of the marriage is a huge factor, especially for duration.
Okay, ability to earn, ability to pay, lifestyle, marriage length. What else?
Each spouse's contributions to the marriage. The source specifically highlights contributions that enhance the other spouse's earning potential, like supporting them through school or helping build their career. The age and physical and mental health of both spouses matter. And while it depends on the state, the source lists marital misconduct as a factor that some states consider when deciding alimony.
So fault can sometimes creep back in, even if the divorce itself was no fault.
In some states, yes, specifically regarding alimony decisions.
The source also lists different types of support orders. Can you run through those?
Sure. The source outlines several ways it can be structured in the Figure 3A table. A lump sum payment is a fixed amount, usually not modifiable unless there was fraud. Permanent support is intended to last for the recipient's lifetime, unless circumstances change significantly. Typically awarded after long marriages, the source suggests 15 years or more as a common guideline. Limited duration support is often used for shorter marriages, where there's still an economic need, but it's expected to be temporary. Rehabilitative support is specifically timed to allow the recipient to gain skills or education to become self-supporting. Reimbursement support is rarer. It's to pay back a spouse for sacrifices made that directly boosted the other spouse's earning capacity. And palimony support between unmarried partners after a long relationship ends is mentioned but noted as available only in a few states.
A whole menu of options depending on the situation. Use of support is generally modifiable. What's the standard for modification of spousal support?
Right. Even orders called permanent can usually be modified later. The party asking for the change has to show a significant and continuing change in circumstances. This change usually relates to the recipient's needs or the paying spouse's ability to pay.
Are there specific examples from the source about what does or doesn't count as a significant change?
Yes, some important ones. If the paying spouse willfully or voluntarily reduces their income, like quitting a good job without a good reason that generally will not be grounds to reduce their support obligation, courts don't reward that.
Makes sense.
The death of either spouse automatically terminates the support obligation. If the recipient spouse remarries, that may terminate support, depending on state law. If the recipient cohabits with someone new, support might be modified, usually reduced, if their financial need decreases as a result, but it's not always automatic termination. Interestingly, the source notes that temporary support paid during the divorce, alimony pendent lite, is usually not affected by cohabitation, and the effect of the paying spouse's retirement varies by jurisdiction.
Lots of triggers for potential modification there. What about basic jurisdiction issues for support orders, getting the court involved in the first place?
Like any court case, the court needs two types of jurisdiction. Subject matter jurisdiction, the power to hear this type of case, family law, and personal jurisdiction power over the specific person being ordered to pay. State residency requirements also play a role here.
And the source mentions the divisible divorce doctrine. That sounds complex.
It can be. It basically means different parts of a divorce might need different jurisdictional bases. A court in state A might have power to grant the divorce itself, change the marital status because one spouse lives there.
Okay.
But that same court in state A might not have personal jurisdiction over the other spouse who lives in state B, especially if they have no connection to state A. So state A could grant the divorce, ending the marriage, but it might not be able to issue orders about alimony, child support, or property division that are binding on the spouse in state B. Those issues might need to be decided later in a court that does have personal jurisdiction over both spouses, like maybe in State B.
So you could be legally divorced in one state, but still have to litigate the money issues somewhere else.
It's possible under the divisible divorce doctrine, yes. It highlights the importance of getting personal jurisdiction over the defendant for financial orders.
Good to know. Any notes on costs?
The source mentions that indigent parties, those who can't afford court fees, can't be blocked from getting a divorce just because they can't pay filing fees. But there's generally no right to a free lawyer in divorce cases, although a court might order the spouse with more money to pay the other spouse's attorney's fees.
Okay, that covers spousal support. Let's pivot to child support. How do the sources frame this obligation?
Child support is presented as a fundamental duty. It's payment from one parent to the other specifically for the child's upbringing and needs, a core principle emphasized. Child support is the child's right, not the parents'. Parents can't bargain it away.
And this applies even if the parents were never married.
Absolutely. The sources state clearly both parents, married or not, have a legal duty to support their unemancipated child until at least age 18. Some states extend this duty through college or even longer if the child has special needs. The actual amount paid often gets adjusted based on how much time the child spends with each parent.
And another critical point the source makes, connecting back to custody.
Yes, extremely important. A parent cannot be denied visitation rights just because they've fallen behind on child support payments. The issues are kept separate legally. Failure to pay support has consequences, but blocking access to the child isn't supposed to be one of them.
What if parents try to make their own agreement about child support?
They can make agreements, but the court always has the final say. Parents cannot legally release each other from the duty to support the child or make an agreement that jeopardizes the child's welfare. Any parental agreement about child support needs court approval to ensure it meets the child's best interests.
And for children born outside of marriage, non-marital children, are their rights to support the same?
Yes. The source confirms they have the same right to financial support from both parents, the same eligibility for government benefits, and the same rights in wrongful death lawsuits as children born to married parents. They can also inherit from their father's estate, but only if paternity is legally established.
Okay, so establishing paternity is the crucial step there. How is that done legally, according to the sources?
Establishing paternity legally identifies the father, which triggers his support obligation, but also potentially gives him rights like visitation or custody. The sources list several ways, figure 3A. A court order after a paternity lawsuit, the father voluntarily signing the birth certificate, signing a formal acknowledgement of paternity, court-ordered genetic testing, which is usually very decisive, testimony about statements made by deceased relatives about who the father was, medical evidence about conception, or the father simply admitting paternity in court.
Is there a time limit for establishing paternity?
The source notes there can be time limits, statutes of limitation, but they have to be constitutional, meaning they must give a reasonable amount of time to actually file the case and be related to a valid government purpose.
And there's a presumption if the parents are married?
Yes, the marital presumption. A child born to a married woman is legally presumed to be the child of her husband. This presumption usually also covers kids conceived via artificial insemination if the husband consented and a doctor was involved. There's also this interesting concept called paternity by estoppel.
Testable, meaning someone is stopped from denying paternity.
Exactly. Even if a man isn't the biological father, he might be legally estopped, prevented from denying he owes child support if he acted like the father. The conditions are usually: 1, he represented to the child and others that he was the father and would provide support. 2, the mother relied on that promise. Maybe she didn't seek support from the real father because of it. And 3, the mother would suffer financially if he were now allowed to deny paternity.
So holding someone to their word and actions, even without biology. Fascinating. Now, what if the parent who owes support lives in another state? How does the court get personal jurisdiction over them?
This is where that big uniform law, Uniform Interstate Family Support Act, comes in. The sources say it's adopted everywhere. UIFSA has specific long-arm provisions to reach out and establish personal jurisdiction over an out-of-state parent just for child support purposes.
How did that work? The source has the PC-by-4 mnemonic?
Right. PC-by-4 helps remember the ways UIFSA allows jurisdiction. Figure 3A. Personal service on the parent while they're in the state. Consent by the parent, like showing up in court. Past residency in the state with the child. The parent caused the child to live in the state. The parent previously lived in the state and provided prenatal expenses or child support there. The child might have been conceived in the state. The parent asserted parentage in the state's putative father registry, or any other constitutional basis for jurisdiction.
That PC/4 is super helpful. Lots of ways to establish jurisdiction under UEFSA. Okay, so jurisdiction is set. How is the actual amount of child support calculated?
It's primarily based on state-specific child support guidelines. These guidelines create a rebuttable presumption, meaning the amount calculated using the formula is presumed to be correct.
Rebuttable meaning it can be challenged.
Exactly. A parent can argue the guideline amount is unfair or inappropriate in their specific case. A court can deviate from the guideline amount, but the sources say if they do, they must make specific written findings explaining exactly why the guideline amount wasn't used.
And what income is used in these guidelines?
Typically, it's based on the parent's income from almost any source. Wages, bonuses, self-employment income, sometimes even benefits. The cost of medical insurance for the child is often factored in too. Usually the premium paid by one parent is deducted from their income before support is calculated.
And the sources mentioned different methods states use in their guidelines.
Yes, there are a few main models. Figure 3b. The most common is the income shares model. This tries to give the child the same proportion of the parents' combined income as they would have received if the parents lived together. Another is the percentage of income model, where support is a set percentage of just the non-custodial parent's income based on how many children there are. And then there's the Melson formula, which is a variation that first makes sure each parent's basic needs are met before calculating the support amount.
So the exact calculation method can vary state by state. Are there other additional factors courts might consider besides the raw guideline numbers?
Yes, while the guidelines are the starting point, courts can look at other things listed in Figure 3b to make sure the final amount is right for the child's situation. Things like the ultimate best interests of the child, the ages of the children, if the parents have other support obligations, like to kids from another relationship, the parents' assets, significant medical expenses not covered by insurance, the standard of living the child was used to, and any special needs the child might have, like costs for therapy or special education.
So guidelines provide the framework, but there's some flexibility for specific circumstances as long as the court explains it. Now, modification again. Modification of child support.
Yes, like spousal support, child support is generally modifiable. The standard is similar. You need to show a substantial change in circumstances. This change has to affect the child's needs or the parent's financial situation, and it needs to be something expected to continue long-term, not just a temporary blip.
And that rule about quitting your job.
Absolutely applies and is stressed again here. A parent voluntarily reducing their income without good cause is not a valid reason to lower their child support. The parent asking for the modification has the burden of proof. Changes usually only go back to the date the modification request was formally served on the other party.
How does UEFSA handle modifying an order from another state? Seems tricky.
UEFSA has clear rules to prevent chaos. Generally, the state that issued the original child support order keeps exclusive, continuing jurisdiction to modify it. Another state cannot modify that order unless one of two things happens. One, everyone, both parents and the child, has moved out of the original state. Or two, the parents explicitly agree, in writing or on the record in court, to let the new state take over modification jurisdiction.
So the original state keeps control unless everyone leaves or agrees otherwise.
Pretty much. And if the original state's law says some part of the order can never be modified, like maybe duration past age 18, then no other state can modify that part either. It gives strong deference to the issuing state's power.
That promotes stability. Okay, how does child support finally terminate? The source gives us the AMPD mnemonic again, Figure 3b.
Right, AMPD helps remember the endpoints. Support typically ends when the child reaches the age of majority, usually 18, if the child marries before then. If parental rights are terminated legally, if the child becomes legally emancipated before 18, or if the child or the paying parent dies.
AMPED, got it. Last piece on support, enforcement. What happens when someone just doesn't pay?
Courts have strong tools. Contempt of court is a big one. Civil contempt means the parent can pay but refuses. They can be jailed until they pay up. Criminal contempt is for willful failure to pay. That can lead to a fixed jail sentence as punishment.
Jail is a serious consequence. What other sanctions are listed? Figure 3c.
Lots of others. Governments can intercept tax refunds. Non-payment can be reported to credit bureaus, hurting their credit score. States can suspend driver's licenses, professional licenses, even recreational licenses like hunting or fishing. Courts can order seizure of assets like bank accounts or property. Wage garnishment is very common, taking money directly from their paycheck, and the non-paying parent can be ordered to pay the other parent's attorney's fees for having to bring the enforcement action.
Quite an arsenal of tools. And how does interstate enforcement work under UWIFSA?
UWIFSA makes it easier. An order from State A can be registered in State B. Once registered, State B can use all its enforcement tools, garnishment, license suspension, contempt, just as if State B had issued the order itself. But remember the modification rule. State B enforces, but generally only State A, the issuing state, can modify the underlying amount unless jurisdiction shifts.
Okay, that wraps up the complex world of financial support. We've hit property division, spousal maintenance, and child support in detail. Now, let's shift to what's often the most emotionally charged area, child custody and visitation.
Absolutely. This is about where the child lives day to day and who gets to make the big decisions about their life. The sources define custody in two ways.
Okay.
There's legal custody. That's the right and responsibility to make the major life decisions. Healthcare choices, education, religious upbringing, things like that.
Big picture decisions.
Right. Then there's physical custody. That's about who the child actually lives with primarily, the parent providing the day-to-day care and supervision.
And courts often order joint custody.
Very often, yes. Custody can be shared. The key requirements are that any joint arrangement must be in the best interests of the child. We'll come back to that standard. And the parents have to show they are willing and able to cooperate reasonably well on issues concerning the child.
Does joint mean 50-50 everything?
Not necessarily. Joint legal custody is the most common outcome. It means both parents share the major decision-making, neither one having the final say automatically. Joint physical custody means the child spends significant time living with both parents, but it doesn't have to be an exact 50-50 time split. It just means both are significantly involved in the day-to-day.
Got it. Custody fights often cross state lines. The sources introduced the UCCJEA to handle that. What is that?
The Uniform Child Custody Jurisdiction and Enforcement Act, UCCJA. This is another critical uniform law adopted by almost every state. Its main job is to prevent jurisdictional chaos and parental kidnapping scenarios in custody cases. It sets clear rules for which state's court gets to make the custody decisions.
So it decides which state gets to decide custody. How does it do that for an initial custody determination? The sources say there's a hierarchy.
Yes, a clear preference order, Figure 4A. The top priority is home state jurisdiction. A state has home state jurisdiction if it is the child's home state when the case starts, or if it was the home state within the last 6 months, and even though the child is gone now, one parent still lives there.
And what defines the home state?
It's the state where the child lived with a parent, or someone acting as a parent, for at least 6 consecutive months right before the custody case began. Or, if the child is less than 6 months old, it's the state where they've lived since birth.
So basically where the child has been living most recently for a solid chunk of time. What if no state qualifies as the home state, or the home state court says, we don't want this case?
Then you go down to the next level, significant connection jurisdiction. A court can use this only if there's no home state or the home state declined. To qualify, the child and at least one parent must have a significant connection to the state, more than just being physically present, and there has to be substantial evidence available in that state about the child's care, protection, training, and relationships.
Okay, so home state first, then significant connection if needed. What if neither of those fits?
Then you hit the last resort, default jurisdiction. If absolutely no state meets the home state or significant connection tests, then a court in any state that has some appropriate connection to the child could potentially take the case. It's rare to get this far down the list.
Once a court does make that first custody order under UCCJEA, does it keep control?
Yes, this is key. The court that makes the initial valid custody determination gets exclusive continuing jurisdiction. That court, and only that court, can modify the order later unless one of two things happens. One, the court itself determines that neither the child nor the parent still live in the state. Or two, the court finds the child no longer has a significant connection to the state and substantial evidence isn't available there anymore.
So it prevents parents from running to different states trying to get a better custody deal.
Exactly. It promotes stability and stops forum shopping.
Can a court choose not to hear a case, even if it technically has jurisdiction under these rules?
Yes, it can. A court can decline jurisdiction if it finds it's an inconvenient forum and that another state is more appropriate. The sources list factors for this, figure 4b. Things like whether domestic violence occurred and which state can best protect the parties, how long the child has lived outside the state, the distance involved, the parent's financial situations, where the evidence is located, if another court could handle it faster, etc.
So it's about finding the best practical location for the case. What about emergencies? Child abduction fears.
The UCCJEA has a provision for temporary emergency jurisdiction. A court can step in and make temporary orders if the child is physically present in the state and needs immediate protection because they've been abandoned or are threatened with abuse or neglect. If there's no previous custody order from another state, this emergency order lasts until the proper home state or other state with jurisdiction can make a ruling.
Okay, a safety valve.
Yeah.
How does the UCCJEA help enforce a custody order from another state if a parent violates it?
It provides streamlined procedures. You can register another state's valid custody order in your current state. Once registered, it's treated like an order from your state's court. For enforcement, the sources mention expedited proceedings, often requiring a hearing on the very next court day after the violating parent is served. A court can even issue a warrant directing law enforcement to take physical custody of the child if there's a risk of serious harm or removal from the state. The sources also specifically mention the Uniform Deployed Parents Custody and Visitation Act.
Ah, yes, for military families.
Mhm.
What's the key point there?
It provides protections for service members facing deployment. A crucial one is that a parent's past or future deployment cannot be the sole factor used against them when determining the child's best interests in a custody case, unless the deployment is the very reason for the current hearing. It sets up ways to make temporary custody arrangements during deployment and generally prohibits courts from making permanent custody changes based solely on deployment without the deployed parent's consent.
Important safeguards for those serving. Okay, let's drill down into the legal standard that governs all custody and visitation decisions. The best interests of the child standard.
This is the absolute cornerstone. Every decision a judge makes about custody or visitation must prioritize the best interests and welfare of the child. It's not about what the parents want, it's about what's best for the kid. In really tough, contested cases, the court might appoint a guardian ad litem, often an attorney whose specific job is to investigate and represent the child's best interests to the court.
What specific factors do courts weigh when applying this best interests standard?